Welcome back to Don't Say That, and today we have a treat for you. We're going to do something a little bit different, all right? Now, by the way, if you don't have the book yet, grab the book, don'tsaythat.com, the podcast, past episodes. We're having a blast here. Can't believe we're over a year doing this. So today, my partner in crime is not here. Greg is currently dancing I can't remember the name of the dance. Come on, what's the name of the famous dance in Hawaii that people do? He's in Hawaii having a vacation. And he was going to hop on via camera on his phone just to say hi. But then he messages me. He's like, I'm on my way into a massage. I was like, well, we would like to not have you join the podcast from a massage room. So you know what I thought would be really interesting? There's a lot of things going on at the FTC now as changes are happening and leadership is changing and President Trump is passing new initiatives down. But I do not want to cover them alone without him here because I am not a lawyer and some of these things are pretty intense and in depth. They actually put out a calling recently that's really important, I think, about content regulation, about like how content moderation, how like these big social media networks do content moderation. And they put out public calling for commentary from you, me, everyone, like citizens. And I want to know more about that because it sounds to me like they're not happy with the fact that social media platforms can ban people so happily or they moderate content so aggressively. So I'm kind of curious where that's going to go, but I don't want to talk about that without him here. So what we're going to do today, because as we're gearing up and getting ready to announce Compliance Summit, yeah, that's right. You want to come hang out with us for 3 days, dive deep into not just what you can't say, but what you can say, right? As we get ready to dive deep into that and start getting into those promotions and getting you to come to Washington, D.C. area September 9th, 10th, and 11th. We will be here in the D.C. area at a beautiful Ritz-Carlton. It is signed. It is done. We're going to be at this amazing venue. We're going to spend 3 days. It's going to be an epic time. I know. We're going to have a lot of fun, okay? There's a lot of parties being planned. It's going to be a good time, and all the who's of the marketing world are going to show up to this. So I thought, what better than to give you a little piece of the beta compliance summit that we had run, almost a year and a half ago now. That was like a test run, and it went amazing. It was a 2-day event. And in that, Greg explained on stage the difference between Section 5, 13B, and 19. Sounds, I don't want to learn. It's very important because it's fundamentally very important because it impacts how you market every day. There's a level of risk that 13B brings and 19 brings. There was a big court case by the Supreme Court in 2021 that really hurt the FTC's ability to use 13B, which is what they'd been using for decades. And so how does that work? Like, why are your phone sales far riskier than your non-phone sales? I have understood now, the more and more I talk to people, and the more and more I work with clients when we're doing their audits, people don't understand this. So here's what we're going to do, okay? You're still going to get a dose of Greg, even though he's at a massage right now. You're going to get a chance to watch his training at the Beta Compliance Summit that we ran, so that you can see the difference between Section 5, Section 13B, and 19, and then subconsciously, I will have now implanted in your mind the desire to be at Compliance Summit in September. It's gonna be a great time, all right? So more stuff coming up about that. We're just getting the page, the quote-unquote sales page ready for that very soon, and I know and hope that you will be there. All right, so without further ado, Greg, take it away.
Well, Anik, you're super kind to have me here. Just so everybody knows, Anik reached out to me a couple months ago and he had to say, I really want to just share my experience. So he invited me to do that. And that's and I see some familiar faces. I know there's some of you that I've talked to before, that we've been introduced before. So what I don't want to do is bore you for the next 2 days. So I'm going to try to go through things in a very methodical manner that helps you understand who I am and what we're trying to do, and just train. I'm an educator. I'm the grandson of 2 public school teachers, and I spend more time training on these topics than I do anything else. I think that I'm more of Anik used a surgeon. I'm more of I would say, mechanic. I like to get under the hood. I like to kick the tires. I like to figure out how things work, and then I like to try to explain it in terms that you can understand. So I've been dealing with marketers for the last 20 years in this practice. Started after I graduated from law school. I started and I clerked for 1 year the Nevada Supreme Court. So I wanted to see the inner workings of how lawsuits and from the perspective of a judge. And so it's a 1-year position where I actually dealt with, there were 2 of us that worked for the same judge, and we sat and talked to this judge, watched cases and the oral arguments and figure it out. When I got out of law school and out of a clerkship, I came back to Salt Lake where I grew up, and I had my best friend and I, we went to 2 Jesuit schools on the opposite side of the country, and we decided to start a practice together. And the first thing we did was we put our shingle out. We did a whole bunch of different work. We had a publicly traded company that was in Utah that had a regulatory issue with the state of Utah. And they said, well, come in. We got a big law firm that we're hiring, and we're going to handle this lawsuit, but we want you to come in on the side and just do all the grunt work. And, we're 2 dumb kids. And we're like, all right, let's go and do this. So we step into this lawsuit, and we're doing all the, behind the scenes stuff, depositions, and everything else. The night before trial, the large law firm that represented this firm or this company came to them and said, we're not going to do the trial. We'll do opening arguments, closing arguments. We're not going to do anything else. And this was a 3-day trial that was scheduled. So the company came to us, the CEO of the company and the president of the company came to us and said, will you put on this litigation? Because you know it. You've been in the weeds. You've gotten into the trenches. Great. So we're like, we're 2 dumb kids, okay, let's go ahead and take on this juggernaut. And it was a $25 million case at the time. And so we step in here and we do this and we get killed. We just get crushed. But the way that it works is we had a right to appeal, and I won't bore you. Attorneys are like doctors. Sometimes we use Latin terms to make us look important. The term is de novo. We get a request and appeal, which starts the case over again. So we get a fresh scratch. So now I'm on the driver's seat. I'm like, okay, we're dumb. Why don't we sue the state of Utah? Why don't we sue them? And let's sue everybody who brought this action against them too. Let's sue them personally. Because really what I want to do is when I look at an issue for a client, I want a resolution. I'm not really suing the state of Utah because I think I'm going to make a lot of money for my client. I'm doing it because I want to get this resolved as fast as possible for my client. And so it worked. The state came to the table and we ended up settling the case for $250,000. And the publicly traded company fired their general counsel who had gotten them into this position and hired me. And so for the next 3 years, I flew across the United States and I settled and litigated 23 different attorney general suits across the United States. And that kind of started my career on marketing and advertising practice. So for the last 20 years, that's what I've been doing is helping companies kind of identify what the problems are with their marketing practices and help. And it happens to be that probably people in the space that that I've represented or that I've been involved with that. So what I'd like to do over the next 40 minutes or so is kind of walk through some of the general big picture ideas. We're going to start big and we're going to go small. And we're going to get into specific feedback. That's why Onyx said, hey, this afternoon, if you want, let's look at some ads and I'll explain what it is. When Onyx called me, it was a referral from a long-term client and friend of mine who's also a friend of Onyx that introduced us. And the first thing is Onyx said on that conversation, and I'm really transparent about this, I'm not here to steal other people's business or work. So if you have your own attorneys and you just want some feedback, I'm happy to help like that. And that's what I told Onyx. I was like, okay, you've been represented for 15 years. I'm not here to try to steal business from somebody else, but I'm happy to give my perspective. So we spent 2 hours that night, and then that Sunday, he forgot. We spent 3 hours on the phone, and then he disappeared. Just like, okay, which I was happy to do because I was doing a favor for a friend of mine who is a friend of Onyx to help out with it. And I was like, great, use your counsel, go and do this. This is just some pointers from my perspective. I was in the middle of a 4-year litigation with the FTC, so I was happy to give whatever knowledge I could give or convey to him. I was happy to do it. And so it wasn't until a few months later that Onyx contacted me back and said, hey, I've got some questions. Do you mind coming to Maryland and meeting with me? And I was like, sure. Got a cousin that works for Walter Reed. I'll fly out, go to dinner with him and come and spend some time looking at your stuff. And so he came in, had me look at things, and spent 2 days with Joe and Danielle and his fine staff here. And after I looked at it, I was like, this is why you're getting sued. And he's like, well, that's unique. how do you know that this is it? And I'm just like, I don't know. I just live in the weeds on this stuff. So I just know that this is why the FTC's got an issue with it. And so sure enough, as the litigation got more and more calls I got from Audit, more questions he had, and really was wanting to pinpoint like what's going on with this. And you could ask him as he gets up here. But when it got down to the settlement, I basically got transitioned where I was doing most of the negotiation with the commission before it settled. And we finally had this meeting and really came down to the commission's like, well, this is why, this is really what we're narrowing it down to. And it was the exact issue that I had mentioned 7, 8 months before. Now, I'm not a magician. I'm not a rocket scientist. I don't just pull things on a hat. What I am is a methodical. I watch things, so I pay attention. So when I was in law school, I know there's a lot of background. I'm not getting into specific yet. I will, I promise. When I was in law school, I did pretty well, and so well that other students would want to know, like, hey, what are you doing? And they'd harass me. I actually ended up started studying at a different university because I was like, every time I was in the library, people were asking me questions. And I wasn't number one in my class. I had 2 kids and I worked full time in law school. And so I had a whole bunch of other things that I was doing. And so, but the standard answer I would give to other students is I just paid attention in class. And it's a really simple answer. I did well because whenever a professor was in front of the room, anything they wrote on the whiteboard, I put down in my notes. And that's all I focused on. I didn't focus on anything else. I just focused on that. And that's what I studied for the test. And I did pretty well. And I'd give that answer to like my fellow students. They're like, that's too easy. That can't be the case. It's like, you do what you do and I do what I do, right? And it worked well for me. So with the FTC and regulatory bodies, there's no whiteboard per se, right? They're not up there, but there kind of is. There are FTC actions. There's a reason I take so many cases with the commission or regulatory bodies. It's because I keep my pulse on what's going on. So when somebody comes to me and they say, hey, look at this advertisement, or why are you saying this? It's like, well, because this case, this case, this case, this case. Even this week, I don't know if you guys saw, there was a press release just on Tuesday, this Empire e-commerce with full asset freeze, full, TRO, took all their assets, e-com or Amazon store. I was reading that case before I had a half a dozen other clients reach out to me. Hey, did you see this case? I'd already read it. So I keep my pulse on it. For me, that's the whiteboard from the classroom, or these FTC actions. So I have 2 type of clients that I work with generally. Like Onyx said, like there's an approach where, and it's so stupid. I had a client last week I was talking to. It's not a client. It's this company that called me and they were like, well, we'll deal with compliance when the FTC comes knocking our door. And I said, well, good luck, enjoy that. That's not the type of approach I like. The 2 type of clients that I work with are, the first type is people who come to me and they say, hey, I'm an advertiser, I'm in this industry, I'm in this space. Will you look at what I'm doing and help me navigate this so that I don't have an issue with the government, whether it's the FTC or the AG's office? And in doing so, I love this type of client because we have time to change things and pivot, and we can do things around that can help avoid, because every hook, every urgency that you're using in your ads, every time you're trying to get somebody to take action, there's a good way to do it and there's a wrong way to do it. And the thing with marketing that I love is that it's creative, right? But the problem is most marketers get lazy. They go into fast, easy money now, and then all that does is create issues with them with the regulatory bodies. When there's a way to do everything, like Onik yesterday sends me this text and he's like, hey, can I say this? And it was in 2 seconds. And I was like, no, say it this way. It was a slight pivot. It got the same urgency, got the same catch that he wanted, but it was just different and it didn't expose him from risk to risk. So I love working with marketers and trying to pivot that, because it's creativity. It's being, smart. It's witty. It's fun. I think marketing is fun. The second type of client that I deal with is somebody who comes to me and they say, hey, I got something in the mail from the government, or I've got this lawsuit. Help me with this. And I help quite a few clients like that as well. Not mostly so I can see where the commission or the state AGs or whatever regulatory body, where they're going, so I can see what their mentality is. Because when you deal with them on a daily basis or a weekly basis, you get to know, like, pick apart where their mentality. There's an old cartoon called Pogo, and he's got this phrase that says, I found the enemy and it is I, or, it, understanding, keep your friends like the Godfather, and, keep your friends close, but keep your enemies closer type thing. I like to know what they're thinking, because when I understand their mentality and where they're at, then I can advise clients better. So I take a good portion of cases where I'm actually either litigating with the Federal Trade Commission or trying to figure out settlements with them so I can understand what they're thinking so I can help clients. So that's the threshold. I'm going to jump into specifics now as we go through this, because I don't want to bore you all together. We're doing this, as Onyx said, they're recording it for my purposes, just because I wanted to make sure that the content that we're providing is good training. And that if there's something that I'm leaving out, if I've left something out, I want to be able to fulfill those gaps. But this is attorney-client privilege. We're not giving this or disseminating this information to anybody else. So that's my little disclosure before I go ahead and get started on this. I haven't entered into engagement with any of you, so just understand that I'm trying to do as much of this attorney-client privilege, but if there's things you don't want others to know about, then don't raise it in front of the group. I say that every single time I'm with a client. Not in this context. I do wills and trusts as well, and so I do weekly events where our firm does a lot of wills and trusts. And I always tell clients when they're on these welcome webinars, don't tell people, tell me about your specifics. I had this lady that wanted to tell her about their husband had like multiple affairs and was like, don't say that. I don't want everybody to know it. I know you're not going to do that today. It's a different context, but it always makes me laugh, the things that people want to share because I'm an attorney. It's like, oh, I don't need to know that, Pat. Let's just talk about this. So if you don't want everybody else to know your business, then don't say it in front of everybody. Just pull me aside, like Onyx said. You'll have an opportunity if you want to. You don't have to talk to me. The purpose of this really is education. I want to be able to share with you what I know, because I love this stuff. It's pretty awesome. So I went through this. So yeah, I've dealt with multi-million-dollar cases. We've done settlements. We deal with the commission all the time. So this is what I do. Okay, let's get into authority on this and kind of where they're at with this. So it won't surprise you that the Federal Trade Commission gets its name from an act that was enacted by Congress called the FTC Act. The FTC Act gives the authority for the FTC to go ahead and to do this overall global. Now, we deal with a dual system where we have state and federal laws, and so we have to look at both of those. So some of you may have gotten a letter from an attorney general's office or the dreaded Better Business Bureau, which actually has no regulatory authority. That I would equate them to like a pseudo, they think they're the government, but they're not. They're quasi-governmental entity. So the states have laws. Every state has what's called the Deceptive Trade Practices Act that governs everything you're doing. The federal government has the FTC Act. They've got the FCC, and there are several different other acts there that you may have heard of, like the Telephone Consumer Protection Act called the TCPA, or ROSCA, which happens to do with negative options or subscription plans. There are a lot of like sub-acts that are out there that govern this, but the FTC gets their regulatory authority under the FTC Act. And that's something that they've used quite a bit. You may see this case, like this Empire e-commerce case. They also talked about the Federal Business Opportunity Act as well, which is governed by the Federal Trade Commission as well. So there are some sub-acts the FTC also governs, but the FTC gets most of its authority under what they call Section 5. Onyx, like I've heard so much about 5, 13, 19. I try not to get in the weeds too much with clients but I have to at least set the premise of this. Because when Onyx came to me and he's like, hey, so this is what we did as a business in this sense, and I just kept on saying to him, and he can affirm that later. Okay, well, what did you do in telemarketing? What was your telemarketing revenue? And it came down to, and I'll explain why that I focused on that. It came down to their settlement came down to telemarketing revenue. And I'll walk through why that's the case in a second. But Section 5 is a federal false and deceptive practices act. It basically says whenever you're conveying a message to an end consumer, whether they're a business owner or a direct consumer, just so you know, like I have a lot of clients that are like, oh, I only deal with businesses. Well, the FTC has given out releases and they've sued companies right now over the last couple of years and done investigations where you're doing B2B, not just B2C. So just so you know, these principles also apply if you're selling products and services to businesses as well. If you are engaged in any sort of advertising practice with somebody and you create an impression that is not correct, and that's the term of art they use, net impression, and it's their expectations are way different from what you've set, then you're in violation of the act. A couple of years ago, I came to DC, I sat down. The way the FTC is structured is they have the FTC itself, but then they have several sub-branches. Now, one of the sub-branches is consumer protection. And consumer protection is divided into several subsections as well. The subsection that you see all the lawsuits that come to is marketing practices, okay? It's run by a lady by the name of Lois Greisman. And Lois, a few years ago, had us come in as a group of attorneys. We sat down and we had a conversation, question and answer about things. And this is what I'm saying, like, get to know who you're dealing with. So I would sit in these meetings mostly to see what their mindset. And she said a comment in the middle of this meeting, and I'm pretty quiet in these meetings. I don't talk a lot. I just listen to what's going on, but I take notes and I integrate it into what my clients do. And she said this. She's like, okay, let's talk about Section 5. Let's talk about net impression. And so her analogy, not mine, was if you go out there and you offer somebody a Porsche, classic 911 Porsche or a Cayenne or whatever it is, but you offer that, but you call it a Volkswagen Bug, even though you're way over delivering on the product and service. Because hey, if I'm getting a Beetle, but I'm really getting a Porsche, I'm saying, hey, pay me for a Beetle, but you get a Porsche. She says that's a violation of Section 5 of the Federal Trade Commission Act. And I know you're like, no, that doesn't make sense. You're over delivering on what the promise is. It's understanding the mentality of the people that you're going against. And for me, I understand who she is by making that comment. She doesn't live in your world. She lives in her world. So who is she? She went to Brown University, undergraduate. She went to Brown Law, Ivy League school. Her concept of reality is way different from yours, right? She went short-term work for private industry, but then has been in the government for the last 30 years. So her expectations and what she deals with on a day-to-day basis isn't you're in the trenches trying to make money. Hers is regulatory-wise, looking at this from a Ivy Tower perspective. And her interpretation of FTC Section 5 is that. And guess what? That's got to be your interpretation too, because she's the one that signs the dotted line that brings all these lawsuits. So understanding that what impression you leave with the client through your advertisement is key to everything. So if most lawsuits happen because the client, the end consumer or business, has a different expectation because your advertising is telling them something else. And what do I see the most of that? It's where you say, hey, come in here and you're going to make like this Empire e-commerce case. If you looked at the case, what was the impression? The clients who signed up for an Amazon or Walmart store were going to make $10,000 to $15,000 a month. And guess what didn't happen? They didn't make that money. So the FTC brought a suit because their net impression was, I'm going to make 10 to 15K a month, and they didn't do it. So it was a misrepresentation. It was deceptive under the FTC Act, and they brought the case and got a full asset freeze. So having the correct net impression for your clients is imperative. So Anik mentioned this other, 13B. What is 13B? What is this, and why is it even pertaining? So 13B is a subsection of the Federal Trade Commission Act, and for 40 years, the FTC used 13B in order to go after companies, and they did it quite successfully. And I can list a slew of companies where they went in and they sued them, and they got a full asset freeze, and they were able to take and unwind all the transactions and take every gain from all of those sales that they had during the course. And there's cases like Russ Dalby where it's $250 million judgment, or MOA, John Beck, Amazing Profits, which was like $350 million, and they get full asset freezes, and they Ivy Capital, and I can keep on, Tax Club, and I can go on and on and on and on. And so what they did during that 40 years is that federal courts across the United States said, oh, okay, FTC's in here. They said they did it wrong. They say they have the authority to freeze assets and take all the profits from all their sales. Well, great, we're going to do that. Until one dude out of Chicago is like, no, this isn't right. If you look at, and I'm sure it was his attorney looked at it, it was like, you know what? Look at the plain language of 13B. Where does it say that they can come and take their money? Where does it say that they can freeze their assets? It doesn't say anything in that. The FTC has overextended their authority, and the judges across America have allowed this. So we're going to appeal. They lost. It was a securities case. It was an offer. It was an educational offer for a fintech, fin ed space where he was teaching people how to invest in the market, and they were actually investing in the market. And I said, "What? Listen, there's another $200 million judgment after trial for the FTC." And he's like, "Oh, okay, my advertising was wrong net impression. I did this wrong. Okay. But FTC under Section 13B doesn't have the authority to take my assets or to freeze them. So we're going to appeal on this." So the Illinois appellate in federal goes to the Seventh Circuit. So he appeals to the Seventh Circuit Court of Appeals, which, not to bore you, I don't know how much you know about how appeal systems work, but at all trial level is fact, right? That's where you present evidence and have witnesses and deposition. All that evidence that gets submitted to trial is at the district court level. Appellate level is a panel. So you get a panel of judges that look at it. They don't look at whether or not the facts were interpreted right. They look at whether the law was applied right. So it goes to the Seventh Circuit. Seventh Circuit looks at this and they say, you know what? This guy's right. 13B doesn't allow the FTC to have that. So they ruled in favor of this defendant. Well, the FTC gets that judgment, and what do? They pucker, because if they lose their authority on this, how are they going to go after companies to try to stop them? Because what's their greatest tool? Where else in America can you go in and bring an action against somebody, freeze all their assets, not allow them to defend? Because when you get a full asset freeze like Empire Ecom did, you're screwed. You don't have the ability to fight because you don't have any money. You're just sitting there. So now it's like you're forced into a really bad settlement because you don't have any other choice, because it's not just their business accounts that are frozen. It's all their personal accounts too. So it's like, how do I live? They're forced in settlement. And the FTC has been used 13B for 40 years to do that. Shock and awe. Boom. That was always the biggest risk for my clients. Like, oh, if we get an asset freeze, we're screwed, because we can't do it. So we got to leverage. And we'll talk about like what you should do with your assets tomorrow and to try to prepare for I'm going to stop. Best strategy for all of you, good marketing practices, follow the law. But we're going to talk about having things in place that in case something does happen, because I will tell you there are unfair regulatory enforcement actions all the time. It's if you don't know this already, the government doesn't play fair. And they didn't play fair with 13B for 40 years. So this guy wins at the Seventh Circuit. FTC doesn't want to lose this authority. And so this and two other cases get appealed to the U.S. Supreme Court. So the case that actually the title of the Supreme Court ruling is AMG Capital Management, and that which was actually a California case. It wasn't this case, but it's the same principle that applies. So this goes to the U.S. Supreme Court. Not all of you are nerds, but again, I watch whiteboards. So I watched the oral arguments in this case because I was tracking it. And so, you go in front of a panel of judges, the justices, and they're all asking, and I can't remember which of the Supreme Court justices was asking the question, but the FTC attorney's up there is presenting his argument why 13B should apply and allow them to have asset freezes. And so the judge, the justice basically says, well, counselor, this seems pretty aggressive. It seems like this is pretty intrusive. And the FTC attorney, I think, made an error in oral argument. One thing that my judge, when I clerked, always said, don't talk yourself out of good arguments. Don't ever say something that's going to put you in a corner. This guy did. He says, well, we only use this rarely. And the justice is like, whoa, counselor, you mean rarely? There are currently 103, I don't know the exact numbers, but he says like 103 cases and you've used it in 98 cases. How do you say that's rarely? And so he's stuck. So in April of 2021, the U.S. Supreme Court unanimously in AMG Capital Management said the FTC had overreached their authority for 40 years. And I'm not talking 5 to, whatever, not 4, just all of the justices unanimously ruled FTC overextended their authority for 40 years. Now, what does that help? That helps you as future marketers that you under 13B, you can't have a full asset freeze, or they'll come after your, and go after all of the payments you received for some of your marketing practice. I'll explain what the difference for 13 versus 19 in a second. But what it didn't help is all these other companies that for 40 years got screwed, and they couldn't go and reverse their judgments. They couldn't come out of those consent judgments. They couldn't, they were screwed. But for future, so what does 13B actually look at? So 13B covers it's any marketing practices that has to do with non-telesales. So webinars and online e-commerce sales or live events, all of those are under 13B. So if you have a one-to-many offering, a VSL, where you're selling and people buy not by getting on the phone, but they actually buy directly online, 13B would cover that. You do a live seminar where people come to live events and then you sell them products and services, 13B applies. Now, what does 13B still allow them to do? Well, it always has allowed them to do this. They can come in and they can sue you and they can stop you from doing, violating the act in the future. But they can't take your money under this anymore. The U.S. Supreme Court made it perfectly clear that that's not allowed anymore. So what has the FTC been doing since then? Well, they've been scrambling. They've been adjusting. So one of the cases that was just settled is a case that I just was on was FTC versus Nudge, a real estate offering that was out of Utah. So I was local counsel for that case at the very end. So this is one of the cases that I was on there for 4 years fighting against. And so in fighting against it, you get to know what all the clauses are. So that was a $1.3 billion case when the FTC filed the lawsuit. If you look it up, FTC versus Nudge, it'll come up and you can look at the complaint. And it was $1.3 billion suit. Now, they brought that case because AMG Capital Management hadn't happened yet. Our argument was, hey, this same thing, 13B doesn't apply. And so when that case was ruled by the U.S. Supreme Court, we moved for dismissal, and we moved that case from a $1.3 billion case to a $60 million case. Now, why $60 million? That was the telemarketing that had the gross telemarketing revenue for the company. And so what they switched, the FTC switched from 13B in the middle of that case to all their efforts to Section 19. Section 19 is a governance of another rule called the Telemarketing Sales Rule, or the TSR. And so under the TSR, under Section 19, the FTC is arguing that they have the ability then to disgorge profits and revenue that you received and to get asset freeze. So if you look at this Empire Ecom case that just came out, that was done under Section 19. They're claiming that the violations under that were under that, and that's why they were able to go into court and get an asset freeze, because under Section 19, the courts haven't told them that they can't get asset freeze. In fact, there's a lot under Section 19 that they haven't ruled. In fact, we settled the response case, Nudge response to the same case. We settled the case, but I really wanted to go to trial. It was a 5-week trial and jury trial, and I wanted to do it because there's several issues with Section 19 that I think the FTC is wrong about. And so I wanted to go in and have some affirmative case precedent to say, hey, you guys are wrong about this, because there are other cases that are in there. So like when Onyx says, hey, when he brought me in to negotiate, have somebody that understands what's going on, his counsel didn't know what the arguments were. And I had to teach that firm, which was a way bigger firm than mine. Like, hey, okay, well, they're arguing Section 19. So first off, like when they looked at Onyx, they come in and say, okay, you've generated $65 million in the last 3 years. We're going to go after all of that. So when Onyx comes to me, he's like, well, hell, I'm going to be liable for $65 million. I'm like, what's your revenue for telesales? I didn't even, because I knew AMG Capital Management. I wasn't even considering the full thing. I wanted to know what his revenue for telesales was. And then he said, okay. And I was like, well, in my opinion, your max exposure is that. And I know under Section 19, there's a 3-year statute of limitations. So they can't go past 3 years. Now, we'll go through what an investigation looks like, and I'll show you that's part of today. Because I can tell you when I meet with a client, I have a couple, I'm representing on 5 other investigations with the Federal Trade Commission right now. And I can tell you the first thing that I do on the phone isn't about like how to respond. It's what does this mean? And I spend more time like telling them the steps and processes of what an investigation or a lawsuit looks like. We're going to do that today. Because when I talked to Onik, we were laughing about it. He's like, what do you spend the most time when you're talking to a client that gets investigated? Telling them like what the meats, the bolt, how this actually, works, because they don't understand what it is. A lot of times people are like, I got this letter from the FTC. What is this? And I'm like, holy shit, this is like, this is big time. This is a big deal. You can't just throw this on your desk and walk away. This is, and too often it's like getting them to get to a position where they can understand it. Now you all are here, so you understand like, hey, if you get something from the Federal Trade Commission, it's a big deal. So Section 19 is where it's at right now, because when AMG's capital management happened, the FTC pivoted and they went through this. Now, the irony of this is, why hasn't the FTC been bringing actions under Section 19 for the last 40 years? Because they know there's limitations to it, because there's not case law and there's not precedence on this. So they're shooting from the hip right now, and they have these cases. There's been 3 cases in the last year. They've got full asset freezes under Section 19. FTC versus Rando, which is a case out of Florida. Mike Rando ran an offer where he was helping people improve their credit. It was a credit repair type of offer, full asset freeze. Settled within 6 months because he didn't have any money, took all the money. So there was an ability to fight it. Second case was the case that happened just this April, a case out of Florida again, FTC versus, I'm terrible in Spanish. You can look up the spelling on this. It's like Gondololas. So I can spell it for you and I can show you what it is. And we'll go through some of these cases so I can show you exactly what it looks like. Full asset freeze, they're offering kind of a dual. It was a real estate offer, but it was also a Amazon offer. They were doing several different wealth generation offers at the same time, focusing towards the Spanish markets. And so they got a full asset freeze. And then the third one was just Tuesday. They come in and get a full asset freeze against this Empire Ecom business, which was a Walmart, Amazon business where they were making specific representations. The irony of that case, on Monday, a client called me and they were all panicking because they have the same affiliate of these guys, these Empire Ecom, and they were like, hey, I need some guidance on this because this really isn't working. My clients are getting upset. How should I do this? And he's like, how? I know these guys over here. And what they did is they sold the business. So they got the liability out of their name. And I started laughing on the phone. And he's like, why are you laughing? I was like, they didn't get any liability out of their name. If there's a regulatory action, they're going to get nailed. They can't just sell the business and be like, oh, it's not mine anymore. You can go after that. In the FTC tax club case, Ted Johnson was one of the principal owners of that case. He sold 2 years before that. He still was brought into that, and he had to settle out that. And that was 2 years before. In the FTC versus Thrive case, the Rasmussen brothers had sold out of Thrive for 2 years before that case, and they still had to settle as part of that. So I laughed at it, and then the next day, this press release came out, and I didn't know Empire e-commerce was going to get sued. So the guy calls me up the next day. He's like, what do I need to do? Or like, now he's listening to me. That's like, there's no shortcut. The thing that I'll tell you about this is you're going to get attorneys, or you're going to have some strategy in place and be like, oh, I'm going to do offshore. I'm going to do this and this. There is no shortcut, fast, easy fix to that. There's no way I'm going to go and take my assets and hide them somewhere. That doesn't work. Every single time they pierce through that. Good marketing practices work. And then having a backup plan in case that happens, then you have that backup plan so you can be protected on the other side as well. So Section 19, why they haven't gone after this is because there's not a good precedent. And there's a lot of, I think, problems with Section 19. The problem you're going to have with this as a marketer is, are you going to be the person that's going to go and litigate this all the way through trial? I was representing a client that had spent millions, tens of millions of dollars in a 4-year litigation. And when they got down to it, it was looking at, okay, the maximum exposure of 60 million, or it's going to cost us 12 million to try this. Why don't we just settle for 15? Okay, the business decision, let's settle for 15. I kind of wish they hadn't, not because I wanted to make more money on the case. I wanted them to do it so that we could have some precedence on Section 19, because I think there's some gaping holes that I'll go through. But that's when Anna came to me with his current counsel. That's where I stepped in and said, hey, listen, you're not hitting these holes on Section 19. Yeah, we've got it down to telemarketing volume and how much money they made for that, but there's still some gaping holes on this. And so that's how we were able to get in the negotiations and get it not from a large number, but to a smaller number for on it. So that's something that you have to look about. Okay.